You all would have, I presume, have seen the fuller length bio of Johnny that we circulated in promoting this event. So I'm not going to rehash all of that, but I just wanted to say a couple of things. So obviously, Johnny is one of the foremost experts internationally on comparative constitutional law, the Israeli legal system, and particularly as well the issue of judicial activism and judicial restraint. And we met, Johnny and I, through the International Law and Liberty Society, which is really an outworking of the Federalist Society in the United States. So we met now, Johnny, three or so years ago, and in Johnny's capacity as the founder or co-founder and executive director of the Israel Law and Liberty Forum. And they're a very important group that, like us and like the Federalist Society and like other organisations in the International Law and Liberty Society network, promote a range of different rule of law values: the separation of powers, judicial restraint, public debate and discussion about legal and constitutional issues. And they have done a significant amount of work to try and explain for a global audience what's actually occurring in Israel. Because oftentimes, one of the problems that we have as an international audience is that we get only one side of the picture about what's happening in Israel. A lot of the more politically or legally conservative groups in Israel don't always operate in English, whereas a lot of the more left-leaning or progressive groups are more global in their focus, and so they put out a lot of material in English, and so that gets picked up by international news media, and that does influence the way that we all perceive certain issues. And certainly I think one such example is the judicial reform that Benjamin Netanyahu's government tried to implement a few years ago. And so that really, I think, does put in some context the book that Johnny has written and what he's going to speak about today in terms of presenting you with a better understanding of the current situation in Israel and perhaps, why that project of reform might have been entered into. It's certainly not Johnny's not here to defend the government or its policy position or anything like that, but I just say, at least it gives us some better context to understand what the problems are and were, and perhaps why some of those things were entered into. So we're very lucky to have Johnny joining us today. I'm not going to say anything else now, but I'm going to hand over to him. And could you all, in spirit, join me in making him welcome?
Hey, for me, I'm currently in the U.S. I'm usually based in Washington, D.C. I'm a fellow at the Georgetown Center for the Constitution, but right now I happen to be in a cozy hotel room in North Carolina because I'm speaking tomorrow at the University of North Carolina Law School. So funny enough, this all works out well because it's 9 p.m. my time, and I'd be in the trouble with the missus if we were doing an event at 9 p.m. my time. But as I'm off anyway, I'm in trouble anyway, but not for this. So there you have it. It's really lovely to meet everybody. I would love to tell you a little bit more about the Israeli legal system, some broader issues of judicial activism and supremacy, and of course about my book. Let's start with that because I'm told I'm supposed to say the name of the book at least 3 times during our discussion. So it's Rogue Justice, The Rise of Judicial Supremacy in Israel is our book. And it is available for purchase in Australia from both through Amazon and through the local distributor. Before we kick in, or before we kick off, or before we dive in, I'll start with a few quick disclaimers, or preliminary remarks, which I like to make. And the first is that this book is highly critical of a very central and important part of the Israeli system of government. It is highly critical of the Israeli Supreme Court and what it's done over the past 40 years. And by its nature, it looks at a problem and it focuses very heavily on something which I think is very wrong, which needs to be fixed. But that should not be taken as a condemnation of Israel per se or overall, not as a country, not as a society, not as a system of government, whatever it is. And I think people, including internal critics of my country, are sort of too quick to make that connection between criticizing a particular aspect and a sort of broad condemnation of the country. So I should say Israel is my home. It is a marvelous, wonderful, fantastic country. It is where I was born and where my children were born, where we will continue to live in the future. And really, and the vast majority of the people, including even in the legal system, in the judiciary, are well-meaning, thoughtful patriots. And that needs to be said, I think. The second point, which is, I think kind of obvious to most of you, but I'll say it anyway, is that, the whole reason that I wrote this book is that the details matter tremendously. And I firmly believe in this. And that's why perhaps you couldn't see in the initial time I showed you the book, but it is a hefty tome. Jim Allen really did a wonderful job reading it and commenting on it, but it's there's a lot in there. And that's even after I had to obviously leave much on the editing floor. And I say that because I really do firmly believe that this is not a conversation that can be adequately had at the level of these sort of slogans and headlines and generalizations. This is really something where you have to look closely at the different issues. You have to see them in a very direct and illuminated way to understand their severity and precisely what has happened in Israel. I'll finish this remark just by saying my favorite movie is The Matrix, and I have all kinds of movie references in the book because this is just something that I do. Quite a bit of Monty Python references for the Anglophiles here. But one reference I didn't use, which I should have used from The Matrix, is that Morpheus says to Neo, no one can be told what the Matrix is. You have to see it for yourself. And that's a little bit what the Israeli legal system is. You can make all these vague generalizations, but at the end of the day, you have to kind of do a deep dive. Without further ado, or having said that, I'll step into speaking a little bit more about the book and about the Israeli legal system and constitutional system. And then, as Xavier said, we'll open up for questions. I'll keep my remarks relatively short, probably 15, 20 minutes from now, just because I think the questions are the most important part, and I'd really like to hear sort of your questions to be able to address them. So very, very briefly, I'll say I will give a short sort of overview of the book, but not in too much detail. My book is in 3 parts. In the first part, I sort of talk about the more structural features, what I call the foundation of judicial supremacy in Israel, and that involves both the judicial selection process and the hierarchical or infrastructural shape of the Israeli judiciary. Very briefly, in Israel, the justices of the Israeli Supreme Court have a veto power over who joins the court, meaning who becomes their colleagues and their successors. This is extremely unusual throughout the democratic world. Where it does exist, for example, to some extent in the United Kingdom, this sort of matches a more limited role or more limited power of the Supreme Court. So throughout the Western democratic world, you sort of have a certain insight or a certain consensus that the selection process has to match the degree of power that judges have. If a court can strike down legislation or has considerable sort of so-called political power, then typically the appointments process would be political. It would be by some kind of direct elections or retention elections, or of course appointment by the political branches. Or you might sometimes have a more professional appointments process, which Professor Jim Allen has written a fantastic article on this particular issue of professional appointments, but that's beside the point. But I do quote him in the book on this. But part of this idea is that in jurisdictions in which you have a professional method of judicial selection, then of course the judges wield less power, which is sort of a given. Israel is in this sense unique and unusual in the sense that you have this massive, enormous mismatch between the court's considerable power and the fact that the justices themselves can essentially choose who joins them on the bench. And they've used, and I should say abused this to devastating effect, blocking eminently capable jurists from the court who simply did not align with them ideologically, in particular did not align with their activist or expansionist conception of what the court should do. I talk about sort of the Supreme Court is a court of first and last instance for a host of issues, meaning if one were to petition against a government action, be it a piece of legislation or executive action, they can start immediately at the Supreme Court, and that is also the final tribunal, the final tier. So there's just one hearing, one decision, and we're done. No appellate process of any kind. This is also unusual for a Supreme Court, especially in a common law jurisdiction. And there's much more to be said about this. I go into, of course, great detail in the book. What I won't do right now, I want to go into more detail, but I'll say, really just in the shortest sense, that I talk about this method of statutory interpretation that the court has invented in Israel, where basically can apply statutes in contradiction of their explicit text and of their explicit purpose. The court has invented a standard called unreasonableness, extreme unreasonableness, which has nothing to do, it has no relation to the familiar unreasonableness, Wednesbury unreasonableness from the UK, which you might be familiar with. In the Israeli unreasonableness standard, the court simply reevaluates whether executive action, whether the government action reached the correct outcome, whether it correctly weighed the different competing factors and considerations. And again, this is used to devastating effect, covering all conceivable forms of government action, administrative action. I'm saying this all very quickly because I actually want to skip ahead. There's so much more to be said. I want to skip ahead to the sort of constitutional issues. And what typically happens is I sort of give an overview of these books, which are the pre-constitutional issues, which are extremely important. And then we never end up talking about the constitutional issues. And I think this will be of interest to Australians. So I'll sort of wrap up just the overview part by saying the court also abolished what are called threshold requirements. So it explicitly abolished a standing requirement for petitions against the court. It abolished any notion of justiciability. Justiciability means that some issues are outside the court's purview or outside the court's sort of proper mandate. The court abolished both of these doctrines, which are typical doctrines across the Western and democratic world, limiting judicial power. But I'll stop there for now with our broad overview of issues, and I'll skip ahead to the constitutional issues because I think you might find this of some interest. I'm of course aware that there are various sort of controversies in Australia in terms of the Australian Supreme Court and its treatment of the Australian Constitution. I know there are questions of sort of reading in particular rights, sort of to have a sort of quasi-constitutional status, including potentially striking down legislation. On that basis, I know there's a recurring question of whether Australia should legislate or enact some kind of constitutional Bill of Rights, some kind of federal constitutional Bill of Rights. So bearing that in mind, let's speak briefly, or let's dedicate the rest of our time to talk about the really bizarre and unparalleled situation in Israel when it comes to constitutional law. So Israel was founded without a constitution. The idea of a constitution was briefly entertained in its founding, but ultimately the people who were sort of tasked or who were granted that authority failed to enact a constitution. And Israel proceeded to exist as a system of government of parliamentary supremacy, something with which I imagine you might be familiar. This is similar to the UK system, very similar, in fact, to the New Zealand system, which I'm sure you might be familiar with. So there's no written conventional constitution and no formal document of any kind which sort of limits legislative power. Simple majority in the legislature can enact any sort of governmental change at any level, etc. At the same time, what happens is that the Israeli legislature, called the Knesset, starts enacting something called basic laws. And though the term is borrowed from the German constitution, which is called the Basic Law, these were in fact completely ordinary pieces of legislation. They were recognized as such, they were treated as such, the Supreme Court treated them as such, the legal and political establishment treated them as such. These were ordinary statutes enacted the exact same way that other statutes were enacted by any majority in the Knesset. And the idea was these statutes indicated some potential future importance. So these were ordinary importance. So these were ordinary laws which served as sort of candidate chapters or draft chapters of a future constitution. And this was the idea of the basic laws. So the Israeli Knesset would enact basic law of the Knesset, or basic law of the government, or basic law of the judiciary, right? Treating very important governmental institutions, treating some important other, core governmental arrangements, and they call this basic laws. Now, I won't go too much into the weeds. There are very many, there were sort of fringe opinions throughout the years which tried to claim that these basic laws ought to be treated as a constitution. But the overwhelming majority of mainstream opinion in Israel, in academia, on the judiciary, and of course in the political, public, electoral levels, all of these rejected any such notion, because these were obviously simple statutes in a system of parliamentary sovereignty, and you had no sort of multiple tiers of legislation. You had just ordinary legislation, of which basic law was one type. Of course, needless to say, throughout this time, you had no judicial review. So the Supreme Court of Israel had no authority to strike down legislation, and this was something clear and obvious. The only claim, as I'm sure many of you are familiar, for a court to strike down legislation is a sort of legal hierarchical claim. You have to point to a superior legal norm that tends to be a written constitution, and you can say, we, the court, are enforcing the written constitution, which reflects a broad, social, electoral consensus, etc., and which constrains the legislature itself. And therefore, an ordinary law by the legislature cannot contradict or violate the constitutional norms, etc. And this is the theoretical and practical basis for all constitutional review, all judicial review of legislation across the world. Fast forward to 1995. 1995 brought with it the landmark Bank HaMizrahi case, Bank HaMizrahi. And in that case, the Supreme Court, led by Justice Aharon Barak, and Aharon Barak was sort of the legendary Chief Justice who sort of led the court's shift, its radical shift towards judicial supremacy and judicial activism. The Israeli Supreme Court ruled, lo and behold, that Israel had a constitution. And it looked at two basic laws from 1992, and they were a Bill of Rights of sorts, meaning they were two new basic laws which sort of addressed some fundamental rights. And the Supreme Court deduced that these were the Israeli Constitution, more so that they constitutionalized the rest of sort of the remainder of basic laws, of previous basic laws and future basic laws. And the court could now treat Israel as a constitutional democracy and could proceed to strike down legislation. Now, though we can't really go too much into detail, I'd like to illustrate just how ludicrous this position was. These two laws enacted in 1992, first of all, were not regarded in any way as a constitution. They were enacted just the same way that all other basic laws were enacted, by ordinary majorities. No one treated them as constitutional norms, etc. The sponsors of the bills explicitly said, on the podium of the Knesset, of the Israeli legislature, this is not a constitution. These laws do not grant the court any power that it didn't previously have. We are not creating a constitutional court that can strike down laws. These were explicit things said in Knesset deliberation. More so, these laws were enacted in a twilight Knesset. That means after the government had already collapsed, had already been disbanded, and new elections had been called, so sort of a lame duck or a twilight Knesset, suffering from an obvious democratic deficit. More importantly, these laws were enacted at 4 in.m. with a majority of 32 legislators over 23, I think. 32 maybe over 32 over 21. Sorry, 32 over 21 legislators. There are 120 legislators in the Israeli Knesset, so less than half of the Israeli Knesset even participated in the vote. Less than half of them were in the building. This is how relatively insignificant these laws were considered. No one considered them a momentous constitutional significance, etc. And there are many, many other sort of clear indicators. Perhaps most importantly and most obviously is to simply say these were simply clearly not a constitution. They didn't remotely resemble any of the criteria with which we typically associate a constitution, whether it's the deliberative process beforehand, whether it's the sort of conscious identification of such by the public and by the politicians, and whether it's some kind of special process, whether it's their substance itself. So this was altogether a really mad, a truly bonkers argument by the Supreme Court. And the last thing I'll say about that specific moment is that in that court case, in the Bank HaMizrahi court case, which established, so to speak, the Israeli pseudo-constitution, the very question of the existence of this constitution was at issue. And you had multiple dissenting justices in that court case who were arguing that, or who were explaining why this is completely wrong and why Israel clearly doesn't have a constitution. And this always reminds me of the wonderful saying by Margaret Thatcher, right? That being a country is like being a lady. If you have to say what you're one, you aren't. And we can think about how much exactly that applies today. And this isn't commentary on sort of the various gender controversies. But this is a bit like that, meaning that having an argument over whether a constitution exists seems almost oxymoronic, in the sense that a defining feature of any constitution needs to be its clear and undisputable existence, and the undisputable fact of its existence, not based on elaborate theories of moral philosophy or political theory or constitutional theory, etc. And of course, I should note that this ruling in Bank Mizrahi is 600 pages long, mostly filled with scholarly, academic, constitutional philosophizing, and to some extent sophistry about whether Israel has a constitution or not. So fast forward about 30 years, and this is just about 30 years ago, the Israeli Supreme Court had then proceeded to strike down dozens of laws, dozens of pieces of primary legislation by the Israeli Knesset, based solely on this, ultimately on this ludicrous idea that Israel has a constitution. And that's already something remarkable, because it's worth noting that, throughout the democratic world, there's only 3 clubs, I can say, we might say, with regarding judicial review of legislation. There's a club where you do have judicial review, and in all those countries, there is a written conventional constitution in the sense that we're familiar with. There are countries with no judicial review, and that includes countries without a constitution, like the United Kingdom and like New Zealand. And there are countries without judicial review who do have a constitution, like the Netherlands or Switzerland, and all these sort of backwater authoritarian dictatorships like the Netherlands, Switzerland, United Kingdom, New Zealand, all of which don't have judicial review of legislation. The last club is this very, very lonely club, a bit like Sergeant Pepper's Club, part band something, because the only member in the last club is Israel. Because Israel is the only country in the Western world in which you have judges who strike down legislation without the benefit of a conventional written constitution. And the degree of absurdity of this situation created by the Israeli Supreme Court is often sort of overlooked or glossed over or minimized, both by judicial supremacists in Israel and by sort of spectators abroad. But this is truly just an outstanding feature of the Israeli constitutional order. I'm almost done with my description of this issue. We'll give it a few more minutes and we'll open it up to questions. So over the past 30 years, the court has proceeded to invalidate dozens of pieces of legislation. It has done so amazingly based not only on enumerated rights in these 1992 basic laws. So for example, we have the right to dignity, which the court has interpreted in the widest form possible. I'll give some examples in a moment. But it has also done so based on unenumerated rights, meaning rights which are not explicitly written in these bills of rights in the basic laws. So if you can imagine, on the basis of this, on the flimsy basis of this pseudo non-existent constitution, which was never recognized or established as such, and if you wake up an Israeli in the middle of the night, or you stop an Israeli on the street and you ask them, do we have a constitution? They'll more likely is not say no. And if they say yes, they'll have no idea to point as to sort of where it begins and ends, what its content is, by whom it was enacted and when, etc. So you have this flimsy basis. And on this basis, the court then not only strikes down clear, blatant, explicit violations of these so-called constitutional provisions, but actually does so on the basis of so-called violations of very broad interpretations of these constitution of the sort of protected rights, or even of unenumerated violations of unenumerated rights that don't even exist in the constitutional, so-called constitutional text. So I'll give two quick examples, and I'll say one more thing about the current state of affairs, and then we'll jump to questions. So 2 quick examples. Well, before that, I should say the court's intervention in Israeli legislation across the board ranges from the almost megalomaniac, if that's a word, micromanagement. So sort of just the most minute, irrelevant, minor issues, which in any democracy wouldn't be considered a major issue justifying judicial intervention. And at the other end of the spectrum, you have the court intervening with the most contentious, the most significant, the most bitterly disputed public disputes and political disputes in the country. And again, of course, with very, very little or really with no legal basis whatsoever. Two quick examples. One is Israel had passed a law, the Israeli Knesset had passed a law to run a pilot for a private prison, a privately run prison. And I think Australia is familiar with this phenomenon. And this is something which one might object to, or one might find various reasons why it's problematic or not, but it is certainly a fact that many democracies in the world have privately administered prisons. The Israeli Supreme Court struck down that law. I should note it struck down that law based only on theoretical arguments, in the sense that this prison had not even yet begun its operations. It hadn't even been built yet. So this was only on principled arguments, meaning there wasn't some kind of clear violation of rights in fact that one could point to that the court was objecting to. The court struck this down as an impermissible violation of the inmates' dignity, of the dignity of inmates in a private prison, because they deserved to be imprisoned by the state or something like that, because there's an inherent dignity in being a prisoner of the state and not a prisoner of private corporations. Of course, if you've ever walked into the state-run post office in Israel, or to the state-run national security in Israel, you'll understand just quite how undignified it might be to be at the mercy of the Israeli state apparatus. So that's one example, and this is just an example of a very broad reading of dignity, because one could imagine statutes where, if we had a real constitution, perhaps of a right to equality. Now, this is a whole can of worms. I won't really get into it too much, but I will simply say, and this is important, this relates to the, you might have heard of the draft exemption, the exemption from the military draft for ultra-Orthodox Jews, for Haredi Jews in Israel. This is a major point of conflict in Israel, striking down two pieces of legislation on this issue. What's remarkable, and all this is based on the right to equality. What's remarkable about this is that there is no explicit right to equality in the basic laws, in the 1992 basic laws, or in any basic law. And that's because it was deliberately excluded. It was there in previous drafts, and this is not disputed. This, all commentators, scholars, and the court itself concede this. The Knesset deliberately excluded an explicit right to equality from these basic laws, because they were concerned about precisely this kind of intervention from the court. And what the court did is the court interpreted the right to dignity to include the right to equality. And as one justice put it, one justice critical of this issue, a Supreme Court justice put it, the court showed in through the window what had been let out, shown out through the front door. Or the court snuck in through the window what had been let out through the front door. So this is, again, if you just think about it, these are the most contentious politically, socially charged issues in Israel, genuinely fraught. I mean, these are not arbitrary issues. These are issues with genuine importance to Israeli society, social cohesion, economy, military affairs, etc. Based on a non-existent constitution that the court invented, it then applies a right, a so-called right to equality, which doesn't exist there, which was deliberately excluded in order to strike down legislation of the highest order and most publicly contentious issues in Israel. The last thing I'll say is that a very recent development is that the court started directly contradicting its own theory, because its theory was that the Knesset acts as a constitutional assembly, and that therefore the Knesset, when it enacts basic laws, it in fact is enacting chunks of the Constitution which are already valid and enforceable. And this has been the court's theory all along. Well, the court about-faced recently, really in a process that started in 2017, but really culminated in 2024, when the court decided that it could strike down basic laws. So the court has started to strike down what are, for all intents and purposes, constitutional amendments or constitutional provisions according to the court's own jurisprudence. So the court invents the Constitution, strikes down laws based on the Constitution, and then strikes down amendments to the so-called invented Constitution, just when it decides that it sufficiently dislikes them. I'll finish that point just by saying that Israel, in this respect, I think, reflects and demonstrates obviously a process that we've seen all over the world of judicial, not just expansion of judicial power, but of judges and courts arrogating power to them in a lawless way, power that was never given to them, adjudicating social and public disputes, which was sort of never their territory and without any sort of concrete or firm basis in law. And however, unfortunately, I think Israel is in many respects, or the Israeli case studies in many respects, an extraordinary experiment of what happens when the court gives itself ultimate power to strike down legislation, to act as a partner in legislation, ultimate even constitutional power to strike down pieces of the Constitution without the flimsiest benefit of a constitutional text, without being constrained by the words of a constitution, without the benefit of the sort of authority granted by a constitution, duly enacted by the public and its representatives. And that can be, I think, summarized at this point as to have been a colossal failure, a colossal failed experiment with catastrophic results for Israeli society, for the Israeli political order. We saw some of those results in the 2023 sort of reforms and sort of protest movement against those. We can go into those a little bit more. But unfortunately, this is something which desperately needs to be fixed in Israel, and it serves as an example, as a cautionary tale for countries around the world, including Australia, of what can go wrong, what goes terribly wrong when courts arrogate or usurp so much governing power to themselves without any basis in law or in public authority.
Thanks, Johnny. Now, we're going to have an opportunity for questions and answers. So while you're thinking of your questions, and as I said before, if you could use the raise hand function that you'll see at the bottom of your screen. If you've got a question, I would certainly like to use my prerogative to ask the first question, and then we'll go to David Laneholm. So, Johnny, one of the things that you mentioned early on in your talk today was the effective veto that the court has effectively granted itself on judicial appointments. And I just wondered whether you could say a little bit more about that, how that came about and what the effect of that has been, and how that might be reformed to remove that veto. Because just by way of background, many of you on the call today may have seen at the conference that the Society held last year in Perth, I gave a paper on this subject of judicial appointments. And one of the issues that I raised was that we have to be very careful following countries like the United Kingdom and trying to professionalise the class of people that are appointed as judges. I think Israel is perhaps one of the most frightening examples in the world. So, Johnny, could you perhaps say a little bit more about that?
Absolutely. I'm just jotting down some notes here to myself on the side. I'll try and answer briefly just because I can see a few other hands up there. Well, how it came to be is actually quite interesting in the sense that this would, unlike the vast majority of things I talk about in the book, and unlike many of the problems of judicial supremacy in Israel, this problem, at least initially, or this system, was not created by the court. This is a statutory arrangement, or meaning it's a rule by law. It was passed in 1952, so very, very early in Israel's history was this system put in place. You have a 9-member committee, and I'll go in a bit more into the details. You have a 9-member committee which appoints judges in Israel. Remarkably, only 4 of those members are elected representatives. So, 2 are legislators and 2 are cabinet ministers. And then the other 5, so a majority on this committee, belong to the legal establishment. 2 are sort of the Professional Lawyer Association representatives, the what's called the Israeli Bar Association, essentially representing the legal profession. And 3 are sitting presiding Supreme Court justices. And one might say, I think there are genuine principled objections to a system like this, wherever it may be in whatever context. But this was considered tolerable in many senses in Israel for many years. And one main reason for that is that until the early 80s, until Justice Aharon Barak came along and sort of reversed the court's jurisprudence, the court did adopt a relatively restrained worldview, especially regarding its own power, especially regarding the degree to which it could intervene in governmental issues, in societally contentious issues, etc. And what changed remarkably is 2 things. One is the accrual of the court's own power, meaning as the court gained more and more power, began intervening in greater and greater things in government, began developing doctrines that granted itself more and more power, then as a natural byproduct of that, the method of selecting judges became more and more controversial. And everyone saw this coming, meaning critics of the court all the way back to the early 1980s called it right away, and they started saying, look, guys, if the court continues down this route, one of the first things we're going to hear is calls to change the way the judges are selected. But more importantly, perhaps, and I think this is really worth looking at in more detail in the book, the court has, in fact, abused this system in very, very direct ways. And the court doesn't see itself, in a sense, as a partner, or it doesn't see itself in its as someone who's supposed to veto only sort of outrageous candidates or people who are clearly unfitting for the role, etc. The court's view, as a matter of fact, is that it simply blocks any candidate who does not share the court's expansionist view of the court's power, typically who doesn't sort of belong also in terms of their political ideology and value-based ideology, etc. The court has blocked the appointment of some of Israel's most eminent, most well-respected jurists. The classic example is Professor Ruth Gavizon, who studied under H.L.A. Hart at Oxford, and she was one of Israel's greatest jurists of all time. She was sort of a very, politically, she was a moderate and a centrist. She had established Israel's major civil rights movement, civil rights sort of legal association, and just as all around, just considered one of Israel's greatest jurists since its founding. And yet she was blocked by Aharon Barak, by the court, in their own words. In Aharon Barak's own words, he said, because she has an agenda. And then he later said, because she wasn't part of the family. These were the Aharon Barak's own words. And I wonder if he was sort of invoking the Godfather with the, you never go against the family. I'm not sure how. I don't even think he knew how mafia-esque his remarks were. But there are many other examples. Meaning, so these things have changed. And what to do about it is a wonderful question, Xavier, because the Israeli Knesset, as part of the reforms package that had been proposed in 2023, the Israeli Knesset eventually, fairly recently, had enacted a very benign reform. Meaning, it tweaked the system a little bit to give a little bit more power to the political representatives on the committee, a little less power to the, it removed the legal profession representatives, and it changed the judicial representatives so that it also included, I think, some retired justices and not only sitting justices, though these were also to be appointed by the sitting Supreme Court justices. So very, very gentle tweaks. I mean, if you can think of a much more serious revamp of that system, would be simply making it much more similar to European or American methods of selection, where, let's say, the government appoints and the legislature approves, right, by ordinary majority. These are standard things throughout the democratic world, but Israel did none of that. However, that particular law, which is a basic law, meaning it's an amendment to the so-called Israeli constitution according to the court's own jurisprudence, that is now before the court. It has been challenged, and it is fairly likely that the court will strike it down. And this is according to the court's new, absolutely wonky and crazy jurisprudence that it can strike down constitutional amendments of this form. So unfortunately, we're a bit of at a loss of what can be done further. There are, of course, some solutions, but I'll stop there. I see a number of hands up.
Thanks, Johnny. We'll go to David Lanehelm now.
Oh, thank you, Xavier. Very interesting, Johnny, very interesting. I've been following this issue for some time, but I obviously didn't know it all that well. If I can sneak in two questions, because I don't want to try and have a second bite. I'm interested in the politics of it. Would it be feasible for the government to simply decline to nominate people to the court so that it essentially withers on the vine as a kind of a blackmail to say, well, if you don't stop what you're doing, you're not going to have a future? And
excellent question.
And if I can get a second bite at the cherry while I have the floor, can you just explain a little bit more what motivated those huge demonstrations in 2024 against what the government was seeking to do? I never quite understood what brought people out into the street over it. What were they cranky about?
Absolutely. Xavier, can I suggest that we also collect the two other questions from Warren and Alexander, and then I can sort of answer all these questions in a holistic way?
Yeah, sure. Warren, would you like to go next?
Yes, my question is to do with the unwritten constitution, which Rabbi Meir Kahane said the constitution was the Torah. Why the Supreme Court will not refer to the Torah in any of its rulings? That'll do. Thank you.
Thank you, Warren.
Thanks, Warren. And Alexander.
I guess my question was whether you the constitution, more like the UK, constitutional principles. Warren's question about biblical or rabbinic ideas influencing the way that makes decisions.
Unfortunately, I was not able to catch most of that. Xavier, were you able to catch that?
I think, Alexander, if you could maybe try again, there was a little bit of
maybe. Can Alexander type it in the chat? Is that a?
Yeah, or type it in the chat. If that works, Alexander. There was a little bit of a lag on that just now.
Right, there was some signal issues. How about maybe Alexander will try and type this out in the chat if you can, and I'll start off with answering David and Warren's question. And thank you, everyone. And please feel free to raise your hand if you have more questions. So these are all excellent questions. I loved especially, David, your first question about, can the politicians simply decline to nominate judges? And the answer technically is yes, and practically now, legally, no. So technically, you're absolutely correct. And in fact, the law explicitly mandates, hang on, pardon me for one moment, there's some background noise here from the AC in the room. So if you give me 30 seconds, I'll be right back.
And while Johnny's attending to that, Charlotte Terrell from my office will post momentarily in the chat some links to where you can acquire Johnny's book. So Alexander, if you can put your question in the chat, and also that will also give everyone a good excuse to look there for the links as well to buy Johnny's book. But back to you, Johnny.
Wonderful. Okay, sorry about that. So yes, excellent question, David. So just to say, the law specifically says that this committee is convened by the Justice Minister, by the Minister of Justice. And in this sense, at least in theory, the Minister of Justice can simply say, very well, if you're not playing ball, I won't convene the committee, and we will not nominate any justices to the various courts, both judges in trial courts, as well as, of course, appellate courts and the Supreme Court. And this, in fact, has been used in various sort of disputes between the government and the court over the years. No one ever thought that that was illegal. This was a fully proper use of the Minister of Justice's power. Even, one might make a good argument that this is part of the checks and balances of the system, where on the one hand, the court has this power over nominations. On the other hand, the Justice Minister has this sort of general veto where he can just refuse to convene the committee. And for various reasons, even that power is not as strong as you might think, because, of course, politicians have an interest in getting things done as quickly as possible because they need to be reelected, whereas judges can play the long game. And I think in this game of chicken, they have the upper hand, because justices can just say, very well, don't appoint any judges. We'll just wait for the next round of elections until someone else who's more amenable comes along, which has in fact happened historically on a few of these occasions. However, after having said all that, in a number of recent controversies, believe it or not, the court has mandated that this committee comes together, meaning this is exactly what happened. The Minister of Justice refused to convene the committee. The court then ordered that the committee come together under protest, meaning without the Justice Minister even being present or participating in this meeting, let alone, of course, not convening a meeting of the committee, and it then proceeded to make various decisions. And one of those, a very famous one very recently, is that they appointed the Chief Justice. They appointed Justice Amit as Chief Justice of the court without the presence of any of the political representatives, because they had all refused to come because the Justice Minister himself did not convene the committee. So in theory, legally speaking, technically the answer is yes, the minister could do that. But in fact, unfortunately, the court has undermined even this basic limitation on its own power. And at this point now, what it means is the court can essentially simply appoint its own justices if it so chooses. What were the demonstrations about? I'll save my answer about that for the end. So let me circle back to that in just 1 minute about the demonstrations and sort of the more, the public discourse in Israel. Warren asked about the unwritten constitution of the Torah, or how the court sort of relates to these things. So funny enough, one could, I think, make the argument that the Torah, or the scripture and Israeli and Jewish sort of the Jewish biblical texts serve as some kind of unwritten constitution, or a written element of Israel's unwritten constitution. I'm not sure that's really true, in the sense that I think at the very early stages of Israel's founding, it was founded as a deeply secular state with almost, I won't quite say hostility, but deep suspicion of sort of religious texts of that kind, and sort of deep wariness among large parts of Israeli society about sort of adopting religious rules as governmental rules or societal rules, etc. Funny enough, in the 1980s, the Knesset enacted a law that tried to do something like this, where they said if there was a lacune, if there was a gap in the law, so previous Israeli law had said that we should look to common law for the answer, and then this was changed such that courts were supposed to refer to the principles of justice and equity and something which are found in the prophets of the people of Israel, or something like that. Is this some very generic, vague, a generic and vague allusion to justice and peace and equity found in the Bible? And of course, as one might expect, the judges simply use this as yet another crutch to sort of insert any principles they found appropriate and relevant as they wanted. I should say that the flip side is that the Israeli Supreme Court treats legal sources in a very fluid and unprincipled and undisciplined way. So courts throw in sources all the time with no legal standing and no legal substance. And this can go from it might as well be social media posts, but they'll throw in academic articles, or throw in chunks and different pieces from Israeli from Jewish religious sources and texts. Sometimes you'll have pieces of poetry, and this is one reason that Israeli Supreme Court rulings run in the hundreds of pages. It's the major ruling in 2024 about constitutional amendments was 750 pages long. And one of the reasons is that judges just kind of feel free to bandy about sort of any source they want, and they just engage, they just embark on these voyages of intellectual and spiritual and or whatever else it is, explorations of different issues. And then let's see what Alexander asked, and then I'll come back to our question on the demonstrations. Does Johnny have any thoughts? Sorry, my question is whether Johnny has any thoughts on the distinction between a capital C constitution and lowercase c constitution, or whether the latter might be more aptly described as Israel's arrangements. So the short answer is yes. And then I'll get back to Warren's question as well. Throughout Israeli history, it was agreed and understood that, of course, Israel had a lowercase c constitution. It had essentially an unwritten constitution. One can make the argument that every country in the world has a lowercase c constitution, to the extent that we define a lowercase c constitution as just a description of the country's governing institutions, etc. But even a more expansive idea of an unwritten constitution, meaning there are some limits on governing power or various arrangements and checks and balances that don't amount to a written constitution with a capital C, but are still of a constitutional nature. And I think one might say that Israel had that as well. However, this is precisely the sleight of hand that the Israeli Supreme Court did in 1995 and has been operating ever since. Because the Israeli Supreme Court did what no other country in the world would ever think to do, which is say, all right, we have an unwritten constitution with a lower C. Let us simply upgrade that into a capital C, capital C constitution without a constitution, without a written constitution. Meaning, let us treat the unwritten constitution as though it were a proper written conventional constitution. And of course, the defining principle, one of the most basic distinctions between an unwritten and written constitution, is only the latter can justify judicial review. Only a written constitution throughout all democratic theory, throughout all democratic Western practice throughout the world, only a written constitution can conceivably justify a court striking down legislation. And this is the extraordinary thing that the Israeli Supreme Court did. It took an unwritten constitution, pretended that it is a written constitution, and then began striking down laws as if this were sort of just a mere technicality, as if this is just a sort of, just a natural development where an unwritten constitution just morphs into it transforms into the written constitution. I think I write in the book that this is the method by which, Barak turns the unwritten constitution copper into the constitution gold, or into the gold of the written constitution. This is the alchemy that Barak engages in, that the Israeli Supreme Court engages in. And I see Warren has a question about Ayelet Shaked in Australia. Warren had the opportunity to speak to her about her legislative changes. And the question is the Israeli Supreme Court more amenable to taking notice of the Knesset if it is controlled by a leftist government? I think it's kind of a moot question, and to sort of paraphrase Warren's question, it is, would the Supreme Court play along more or better if it were a left-wing government enacting some of these changes? I think the answer is yes, in the sense that substantively, many of the changes proposed in 2023 were previously endorsed by left-wing governments. They were, posited or advocated for by left-wing governments, by left-wing academics, by judges, etc. So certainly part of the resistance to them was simply because they were being advanced by a right-wing government. On the other hand, it's a moot question because some of these questions would never be advanced by a left-wing government. And this has something to do, I think, with coming back to our last answer, or to the previous question by David, which is that the system of judicial supremacy as it has come about in Israel has clear winners and losers. It has clear beneficiaries. And the major beneficiaries of judicial supremacy in Israel today is the political left. And what that has meant is that the political left could get its way on many ideological issues, on sort of key policy issues. The Israeli political left could get their way without winning elections, without persuading the electorate, without negotiating with other sort of political and electoral groups, without building political coalitions with other parties and creating government, without having to compromise critically, without having to compromise in any way. So the political left has really no incentive to change any of these things. It has no incentive to cooperate with any right-wing government in order to advance these changes. And this is kind of part of the tragedy which has created a great deal of the strife and controversy surrounding legal reform as we've seen it in 2023. And I'll move just quickly to answer David's question about the demonstrations and the protest movement. The first thing I'll say is that, and I know we're almost out of time, Xavier, I'm towards wrapping up. I don't want to belittle what many of these demonstrations and protesters were doing, in the sense that many of them were, well-meaning patriots who want the best for Israel and who were protesting against something which they were convinced was deeply troubling and very bad for the country, et cetera. And I would never doubt their right to protest. Setting aside for a moment some of the patently illegal elements of those protests, which should have been, where the law should have been enforced more seriously. But of course, they're allowed to protest, and I respect them for doing so. However, having said that, someone once asked me in an interview, do Israelis really prefer rule of judges over democracy? And my answer was that for many Israelis, they don't know that there's a difference. Many Israelis don't know that there's a difference. And a great many Israelis, a large proportion of Israeli society, has been taught and has been convinced that the meaning of democracy and that Israel belonging to the family of Western democracies means that there has to be a layer or a caste of unelected ex-lawyers in gowns who can impose their policy views on all of society, who can sort of arbitrarily tell society what it can and cannot do, which outcomes of the political process are acceptable and which are not acceptable, and all of this without the slightest or flimsiest basis in law, in public consensus, in written constitutional instruments, etc. And a great many Israelis genuinely believe this. And this speaks to something that Xavier had said really right at the beginning, which was spot on, which was absolutely correct, which had to do with this sort of scarcity of information available to people outside Israel, to observers. And this is absolutely true, and I make this point in the introduction to my book. But that process works both ways. And Israelis have a very hard time understanding what happens in the rest of the world. Israelis generally do not have a window into other Western democracies the same way that Australians do, because Australians share a common language with numerous other countries around the world. and democracies around the world. Australians share a common cultural heritage and a cultural legal tradition, etc., with many other countries around the world. And Israel has really no peers in that sense with whom they can sort of learn from and with whom they can sort of naturally associate with. And one of the outcomes of this is that a great many large proportions of the Israeli public have been persuaded and have really always been taught that the meaning of democracy is necessarily judicial supremacy, is essentially unelected judges telling everybody else what to do. And without that, we cease to be a democracy. And this has fueled a great deal of the protests. I'll say one more word about this and then I'll finish, is that one cannot discuss that issue without discussing the role of legal academia and legal scholars and maybe, sort of the legal establishment in Israel. Because some of the people that should know better and that do know better and that have been sort of propagating this lie, this falsehood, are the law professors and are the so-called constitutional law experts, et cetera, in Israel. And these people, even though they certainly know better, have blatantly been telling the Israeli public that if any of this were fixed, or if that the court's power were reduced, then Israel would automatically become an autocracy or an authoritarian dictatorship. And this was the end of Israeli democracy if politicians were more involved with selecting judges. Or Israel would no longer be democracy if the court couldn't arbitrarily strike down any law that it wanted with no textual basis and without a constitution, etc. And I think they have great responsibility for that. And I think, and to end on this note, I think the international community has a part to play there in educating the Israeli public, in contributing to the Israeli debate on these issues, in lending their perspective by showing them what happens in other countries and the variety of available systems and methods that we have in democratic countries.
Well, thanks, Johnny, and I think that's timed perfectly for us to wrap up there. But certainly this is just the beginning. If you want to learn more, we've got some links in the chat function here, which we'll send around by email as well, where you can get a copy of Johnny's book, and in fact, even at a discount with the code there that Johnny's very kindly shared with us. So, we're certainly hoping that this will be the start of an ongoing conversation. And I think the point that Johnny just ended on is a very important one and a very good one, that, I think there are certain groups that have a certain view of the world and a certain philosophy or approach to issues of jurisprudence and to other political and public policy matters that are very good at coordinating across boundaries. And there are others, those that value the rule of law and separation of powers and concepts like subsidiarity and federalism that are perhaps less coordinated globally. And I think that part of advancing a sort of a more traditional rule of law oriented value system in both law and politics does involve the discussion and debate freely of ideas. So Johnny, thanks very much for making the time to be with us. I know it's evening for you there, and please pass on our thanks to Shira as well, and best wishes to her and the family for enabling you to do this. And certainly we look forward to catching up with you soon. And I know Gabrielle and I are looking forward to seeing you perhaps in Australia, but we'll have more to say about that in the future. But anyway, can you all join me in thanking Johnny?
Thank you so much, Xavier, and thank you so much to the Samuel Griffith Society, and thank you so much to all the participants today.